Can I welcome everyone to this, the fifth meeting of the Justice Committee in 2014. Can I ask everyone to switch off mobile phones and other electronic devices completely, as they interfere with the broadcasting system, even when switched to silent. Apologies have been received from John Pentland, and we have Graham Pearson here as the substitute. Item 1, subordinate legislation, is consideration of an affirmative instrument. The draft, the draft Proceeds of Crime Act 2002, Disclosure of Information to and by Lord Advocate and Scottish Ministers Amendment Order 2014. This instrument enables the Crown and Procurator Fiscal Service and the Civil Recovery Unit to disclose information to the Law Society of Scotland in appropriate cases, and supports the Council of the Law Society to effectively discharge its functions as a supervisory authority under the Money Laundering Regulations 2007. And I welcome to meeting Rosanna Cunningham, Minister for Community Safety and Legal Affairs, and Scottish Government officials, Alistair Hamilton, Policy Officer, Organised Crime Unit, and Carla McCloy-Stevens, Lawyer, Director of Legal Services. Good morning. Minister, you're going to give evidence in advance of the debate and instrument, I think, by making an opening statement.
Yes, I think it might be helpful just to make a very brief statement. I don't actually anticipate this is a particularly controversial order. Obviously, tackling serious organised crime is a top priority of the Scottish Government, as it would be of any Scottish Government. So this order is aimed at strengthening the proceeds of crime legislation in Scotland. There have been a few cases where a proceeds of crime investigation has revealed information concerning the particular conduct of a solicitor, which, although not criminal, could amount to professional misconduct. However, the Proceeds of Crime Act 2002 doesn't currently permit that information to be brought to the attention of the Law Society of Scotland, who are, of course, the regulatory professional body for solicitors. So the order is intended to rectify this. The Proceeds of Crime Act 2002 regulates the purposes for which the Lord Advocate and the Scottish Ministers may disclose information obtained in connection with their functions under the Act. And these purposes generally relate to the exercise of certain public functions. The order, in effect, extends these purposes to include the exercise of two additional public functions. These are the regulatory functions of the Council of the Law Society of Scotland, as defined by sections 3F and 3G of the Solicitors Scotland Act 1980, and the functions of the Law Society of Scotland as a supervisory authority under the Money Laundering Regulations 2007. And this will enable the Lord Advocate and the Scottish Ministers to share with the Law Society of Scotland any information which concerns alleged professional misconduct or non-compliance with the Money Laundering Regulations 2007 by a solicitor. As a consequence, this will facilitate the Law Society of Scotland in discharging its functions as the regulator or supervisory authority concerned. It will have the opportunity to investigate any such matter and decide whether or not disciplinary action is required. And accordingly, the order both protects the consumers of legal services and provides a further means of disrupting the operation of organised crime groups in Scotland. It is therefore welcomed by the Law Society of Scotland and also by the Crown Office and Procurator Fiscal Service and the Civil Recovery Unit, which exercise functions under the Proceeds of Crime Act 2002 on behalf of the Lord Advocate and the Scottish Ministers, respectively. And obviously, if members have any questions, I will do my best to answer them.
Thank you very much. You've preempted me there. I'll give you any questions, John Finney.
Thank you. Morning, Minister. Minister, is there any retrospective application for this? Presumably there's something that gave rise to the concerns that brings this about.
It doesn't change the law retrospectively. That wouldn't be something that this would achieve, but it switches on a function of disclosing information for specific purposes from the date of commencement. So that small number of cases which have gone before, and there have been, I think, about 10 in total that would have been caught by this, will not retrospectively be caught.
Questions? No other questions, so I now move on to item 2, the formal debate on the motion to approve the instrument considered under the previous item. Can I invite the Minister to move motion S4M 8881 that the draft Proceeds of Crime Act 2002, Disclosure of Information to and by the Lord Advocate and Scottish Ministers Amendment Order 2014 be approved?
Formally moved.
Thank you very much. Do any members wish to speak in the debate on the motion? No members indicated that. The question is that motion S4M 8881 be agreed to. Are we all agreed? Agreed. Thank you very much. As members are aware, we are required to report on all affirmative instruments. Would members be content to delegate authority for me to sign off this report? Thank you very much. Item 3, Tribunals-Bill, Stage 2 proceedings. I'll allow officials to change places. I now move on to item 3, Stage 2 proceedings of the Tribunals-Bill. I'm going to continue this item. Well, I think we could probably get right through it today because it doesn't seem to be that, I'm advised, that controversial. So we'll keep going. It'll be good to get this one out of the in-tray. And then we'll move on to consider a draft 1 stage report on the Criminal Justice Bill. The Minister for Community, Safety and Legal Affairs is staying with us for this item, and I welcome officials to this meeting. Can I remind members officials sitting next to the Minister are strictly in a supporting capacity and cannot speak during proceedings or be questioned by members, just to remind you of that. So any questions will be directed at the Minister. She's on her Todd. Now, members should have the copies of the bill, the marshalled list and groupings are made for today's consideration. And I move on now to the marshalled list. I call Amendment 1 in the name of Elaine Murray, grouped with Amendments 29 and 30. Elaine Murray, please to move Amendment 1 and speak to the amendments in the group.
Thank you very much, Convener. I move Amendment 1. In several of its recommendations, the committee reiterated its view that the particular nature and characteristic of tribunals should be preserved and courtification should be avoided. Recommendation 10 of our report suggests that there should be a provision in the bill setting out what a tribunal is. Amendment 1 gives a clear and unambiguous definition of the term tribunal as a body which adjudicates in matters concerning administrative justice. According to the Law Society of Scotland, there is no such definition in Scottish legislation, and including a definition in this bill will avoid possible current and future uncertainties in the light of proposals to merge the Tribunals Service and the Scottish Court Service. The UK Tribunals Courts Enforcement Act 2007 does contain a definition, and this amendment, and I thought they might all be grouped together, but they're not, but in conjunction with Amendments 6, 8 and 68, would promote parity with the UK legislation and ensure a consistent experience for users of all tribunals in Scotland, whether their governance is reserved or devolved. They would also provide a framework for defining the principles for a new tribunal, any new tribunals which could be created in Scotland in future, and guarantee a standard to which all tribunals should operate. Now, I noticed in the notes which the Minister has very helpfully circulated last night that she feels that there are difficulties in terms of defining exactly what a tribunal is, and that this particular amendment maybe is not flexible enough to allow further tribunals to be added in the future. I'm a little puzzled by that because the amendment only defines it as adjudicating between matters between a person and a state, between different persons, stating that it is independent of both the executive and the legislature, and also a definition of administrative justice. So I'm not quite sure why that would prevent any further tribunals being added in the future.
I'm sure the Minister will clarify, as I'm now calling the Minister to speak to Amendment 29, the other amendments in the group, please.
Thank you. In its Stage 1 report, the committee called for the characteristics of tribunals to be protected in the bill, and the committee sought an amendment which set out general principles similar to those included in the Tribunals, Courts and Enforcement Act 2007. And the proposal to define what a tribunal is and the proposal to include a statement of tribunals' principles became, in my view, a bit confused during discussions of this bill, because they are separate ideas. The distinctive characteristics of tribunals are best protected by including a duty to consider principles rather than by a difficult and limiting definition of what a tribunal is. I see great value in including a statement of principle on the face of the bill, as members of the committee will see when we come to Amendment 11 in Group 3. I'm not convinced of the merits of attempting a definition of what a tribunal is or does in this way. The tribunal system is very complicated. Tribunals come in many different forms, deal with many different subjects, and are varied in their nature, specialisms, and individual ethos. And including a defined statement about what a tribunal is could have the effect of narrowing the field. It may make it difficult when considering what type of tribunal would be suitable to be included in the new structure. The bill reflects this at section 26, which already explains, as far as is possible or appropriate, what is meant by tribunal in this bill. And the difficulty of attempting the sort of definition Elaine Murray seeks can be seen from the text of this amendment, where tribunals are defined in terms of administrative justice, and administrative justice is defined in relation to the work of tribunals, and that's really a circular argument. In addition, the first-tier tribunal and the upper tribunal, as being created by the bill, fall to be defined primarily by reference to the functions conferred on them by and under the bill. In a sense, they are self-defining, and no more needs to be said for it to be understood what sort of bodies they are and what they do. And further, the description of a tribunal in section 26, along with the detailed specification of particular tribunals in Schedule 1, is sufficient for the purposes of the bill. The bill is not lacking detail in the definition of a tribunal, and I don't understand what actual gap in meaning and effect Elaine Murray is trying to fill by her amendment. So I don't consider that anything is gained from the definition Elaine Murray suggests, but I think that there are risks for the sake of future workability of the new tribunal system. The important protection of the essential elements within the new tribunal structure is better achieved by accepting my Amendment 11 when we reach it. Amendments 29 and 30 are taken as part of this group are minor drafting adjustments. Number 29 tidies the numbering in the list at the end of section 26. Number 30 corrects the cross-reference in Schedule 1 to an act relating to parking adjudicators. And I therefore invite Elaine Murray to withdraw Amendment 1.
Before Elaine responds to that, does any other member wish to come in? Margaret?
Yeah, thank you, Convener. I believe actually the definition of a tribunal, notwithstanding what the Minister has just said, is a welcome addition to the bill and does help clarify the characteristics of a tribunal. And I don't see that it really interferes with Amendment 11 that the Minister is proposing, which I also consider to be a welcome addition.
Any other members? I take it you don't wish to respond to that, and I'll just move to Elaine. If you wish to, you can, before I let Elaine wind up.
Just remind members that when you put definitions on the face of a bill by definition, you then are unintentionally or intentionally excluding the possibility that things outside that definition might in the future want to be included. That is why you often do not find such precise definitions in pieces of legislation.
Elaine? Well,
I've been listening to what the Minister says, but I'm still not absolutely certain what sort of tribunal would fall with this definition. I can't imagine what sort of tribunal will be coming in which wouldn't be covered by this definition, so I think I'll press the amendment.
The question is that Amendment 1 be agreed to. Are we all agreed?
Yes.
Are we agreed? I didn't hear anything. I'm blocked. You need to shout. Yes. There's a no. There's a division. Right, those in favour of the amendment, please show. Those against the amendment, please show. There are no abstentions. 4 for, 5 against. That amendment is disagreed. Thank you very much. I just warn you, my deputy and me were struggling here through a head cold which we're sharing, which is a coalition of a cold, yes. So I have to shout. I'll call Amendment 6 in the name of the Minister group with Amendments 7, 31 and 32. Minister, please to remove Amendment 6 and speak the other amendments in the group.
Thank you, Convener. These amendments make provision for functions being conferred directly on the Scottish tribunals by another Act. When a new tribunal jurisdiction is being created, it might directly confer functions on the first-tier tribunal rather than creating a new tribunal and then transferring its functions into the Scottish tribunal structure under Section 27. The bill therefore needs to provide the same power to make necessary legislative changes and to do the required updating as are available when jurisdictions are transferred in. Amendment 31 allows the Scottish Ministers to amend and update the Act in order to accommodate the new functions being directly conferred, and this is in line with powers which already exist at Section 27. Amendment 32 allows the Scottish Ministers to redistribute functions among the tribunals once they've been directly conferred. Again, this is in line with existing powers in Section 27. And this gives flexibility when decisions are being taken about new tribunal jurisdictions that might be considered in future. It takes away the need for new jurisdictions to be created in their own right before they can be transferred into the Scottish tribunals. Amendments 6 and 7 pave the way for this. I therefore move Amendment 6.
Thank you very much. Any other members wish to come in? Minister, I take it you don't wish to wind up? No. Question is that Amendment 6 be agreed to. Are we all agreed? Agreed. Thank you. I call Amendment 7 in the name of the Minister already debated with Amendment 6. Minister, to move formally.
Move formally.
Question is Amendment 7 be agreed to. Are we all agreed? Yes. Thank you. Question is that Section 1 be agreed to. Are we all agreed? Yes. Thank you very much. Call Amendment 8 in the name of Lane Murray, grouped with Amendments 11 and 68. Lane Murray, to move, please, Amendment 8 and speak to the other amendments in the group.
Okay, thank you, Convener. I move Amendment 8, which places a duty on the Lord President in carrying out his or her functions to adhere to the principles for Scottish tribunals, the need for them to be accessible, for proceedings to be fair and handled quickly and efficiently, and for members of the tribunal to be experts in the subjects on which they decide. It also requires the Lord President to develop the innovative methods of dispute resolution, which are such that they may be brought before a tribunal. The duties placed on the Lord President as head of Scottish tribunals and the President of tribunals will ensure that the long-standing principles of tribunals continue to be upheld. The expert status of tribunal members is fundamental to achieving these principles, as they will be able to focus and identify the key issues to be resolved. Amendment 11 in the name of the Minister defines some of the principles of tribunals, and in the absence of my amendment number 1 being passed, I certainly will be supporting Amendment 11. And obviously there's some areas of overlap between Amendments 8 and Amendments 11, although Amendment 8 is a little bit wider. It does include the need for members of tribunals to be experts in the subject matter of the cases in which they decide matters, and also the need to consider and develop innovative methods. However, I don't know that those two amendments would stand together as they are, so it may be that I'll withdraw 8 in the passage of 11 and see if we can add to 11 at stage 3. Amendment 68, sorry, I've got 68 as well. Sorry. Amendment 68 places a duty on the Court of Session in making tribunal rules to have regard to the need for them to be accessible, for proceedings to be fair and handled quickly and efficiently, and for members of the tribunal to be experts on which they decide. The distinctive nature and character of tribunals must be taken into account and protected by the author of procedural rules, and these rules must ensure that users can use the system as easily as possible and that they remain at the heart of the system. Now, I notice that Amendment 11, which covers much of this area, doesn't include reference to the Court of Session, so I'd be interested to hear from the Minister why the Court of Session is not also included in her Amendment number 11.
Thank you. Minister, to speak to Amendment 11 and the other amendments of the group, please.
Amendment 8 from Elaine Murray places a duty on the Lord President to adhere to certain principles. I've reflected on what the committee and stakeholders said at stage 1 about the inclusion of a guiding principle on the face of the bill. And the Government Amendment number 11 sets out the guiding principle, which I believe will ensure that the user is placed at the centre of any proceedings before the tribunals under this bill. This principle is that tribunals' proceedings should be accessible to the user, should be fair to the parties, and should be handled quickly and effectively. My amendment ensures that the Scottish Ministers, the Lord President and President of Tribunals must have regard to the principle when undertaking their respective high-level roles. I believe that my amendment addresses the concerns of stakeholders and the committee expressed at stage 1 by ensuring that the distinctive character of tribunals is respected by those who have responsibility for them. Members of the Scottish tribunals will be appointed on the basis of jurisdictionally specific criteria. There is no question that they will be experts in the subject matter of, or the law to be applied in, cases in which they decide matters. There is no extra benefit in placing a specific duty on the Lord President to ensure this. On this, I would refer Elaine Murray to sections 34 to 37, which provide for the selection of tribunal members on a case-by-case basis. In addition, Section 30 is designed to ensure that tribunal members are assigned in a way that ensures the best use is made of particular expertise in relevant areas of the law. These sections, taken with the appointment criteria in Schedules 3 and 5, will ensure that the right people are in the right place within the new tribunal system. Tribunal rules will be made by the Court of Session, but drafted by the Scottish Civil Justice Council. The SCJC is already required to have regard to principles which already include that the civil justice system should be fair, accessible and efficient, and that rules relating to practice and procedure should be as clear and easy to understand as possible. These principles appear in the Scottish Civil Justice Council and Criminal Legal Assistance Act 2013. The Tribunals-Bill will amend the 2013 Act to require the SCJC to form a committee, including the President of Tribunals and members with knowledge of how the tribunals exercise their functions, who will draft tribunal procedure rules. It is not clear how Amendment 68 would sit with the duties which the bill will impose on the SCJC and the principles which the SCJC already has to observe. I think that the result would be confusing, and I consider that my amendment should be preferred. In my view, Amendment 11 strikes the correct balance between overarching principles and day-to-day operation of the tribunals. I therefore ask Elaine Murray to withdraw her Amendment 8 and not press Amendment 68 when it is reached.
Any other members? Roddy?
Just a small point. I noticed that in the 2007 UK Act, the Lord Chancellor is under a duty to ensure there is an efficient and effective system. We alternate in language between 8 and 11. One talks about efficiency, one talks about effective. So just a small point of detail. I have heard what the Minister says, and I think I largely agree with it. I have particular concerns in Clause 8D as to what I think is a slightly woolly language, developing innovative methods, what that's actually supposed to mean. I'm a big fan of alternative dispute resolution and other ways of settling disputes, but I'm not sure that having this on the face of legislation is quite the way forward. Other than that, I think I largely agree with what the Minister has said.
Yes, I would have commented. I'd quite liked some kind of comment from the government with regard. I agree with the language of innovative methods, but something along the lines of mediation prior to tribunals and so on, some kind of comment. I agree with the Minister's position with regard to 8C. I think that can, from everything else that's taken as read, doesn't need to be in the bill. But I do have some sympathy for 8D, even if it were to be in sort of more acceptable language. But I think there is an issue there about promoting people resolving matters before they go head-to-head.
I think there's perhaps a bigger issue across more than one piece of legislation about mediation. And I'm not sure that bringing this in as a subsection of an amendment in this way would necessarily achieve what we're really looking for, I suspect, across a wide area of government.
Thank you, Elaine.
Right,
to wind up,
yes, thanks very much. I won't press it. Apart from anything else, there will be duplication between, and a certain amount of conflict between the two amendments if they both went through. So I'll withdraw 8. With regard to 68, I suppose I have to come to that near the time. But I think
I'm just asking members if you're content that Elaine Murray withdraws Amendment 8. You are. Thank you very much. Yes. So we move on. The question is that Section 2 be agreed to. Are we all agreed? Yes. The question is that Sections 3 to 9 be agreed to. Are we all agreed? I call Amendment 9 in the name of the Minister, group with Amendments 10, 49, 50 to 53, 73 to 76 and 83. Minister, please to move Amendment 9 and speak to the other amendments in the group if you wish.
Thank you, Convener. These amendments provide more clarity and flexibility around decision-making in the Scottish tribunals. Amendment 52 sets out the arrangements for voting on decisions where they are made by 2 or more members. The Scottish ministers will be able to make particular provision in regulations for individual tribunals. For example, regulations might provide for the chairing member of a tribunal to have the decisive vote in the event of a tie. Amendment 53 makes provision allowing tribunal rules to determine who the chairing member of a particular tribunal should be. These amendments simply provide another tool for particular jurisdictions to use if they require it. Some jurisdictions will never require it. This is not a decision for us now. These amendments are enabling ones, which will help the Scottish ministers and the particular tribunal jurisdictions create the decision-making framework they need. This all sits with sections 34 to 37 as they anticipate tribunals sitting constituted by single members or 2 or more members as needs require. Amendments 74 and 75 allow tribunal rules to make provision for multiple cases to be conjoined or heard at the same time, if appropriate. This is again enabling for the sake of efficiency in the system. Amendment 76 expands on the type of provision which tribunal rules can make in respect of the decisions of tribunals. It provides more detail and more clarity for the sake of completeness of the story. Amendments 9, 10, 49, 50, 51, 73 and 83 make minor adjustments and changes necessary to implement the other amendments. I therefore move Amendment 9.
Thank you very much. Anyone else wish to come in here? Nobody's indicated that. I take it you're not winding up, Minister. The question is that Amendment 9 be agreed to. Are we all agreed? The question is that Section 10 be agreed to. Are we all agreed? Call Amendment 10 in the name of the Minister, already debated with Amendment 9. Minister, to move formally.
Moved.
The question is that Amendment 10 be agreed to. Are we all agreed? The question is that Section 11 be agreed to. Are we all agreed? I call Amendment 11 in the name of the Minister, already debated with Amendment 8. Minister, to move formally. Thank you. The question is that Amendment 11 be agreed to. Are we all agreed? The question is that Section 12 be agreed to. Are we all agreed? I call Amendment 12 in the name of the Minister, grouped with Amendments 13, 14 and 15. Minister, please to move Amendment 12 and speak to the other amendments in the group.
Thank you, Convener. These amendments make changes to Section 13 to make it absolutely clear that all tribunal members have judicial status and capacity by virtue of holding their positions as members. Amendment 15 replaces the current provision which restricts their judicial capacity and status to the exercise of their decision-making functions. The result is that the capacity of members is broadened to cover all aspects of their tribunal work. Amendments 12 to 14 make minor adjustments. In preparing these amendments, I've taken account of representations made to be by interested stakeholders, and I therefore move Amendment 12.
Does any member wish to speak on these amendments? Nobody's indicated. Minister, I take it you don't wish to wind up. Accordingly, the question is that Amendment 12 be agreed to. Are we all agreed? Call Amendments 13, 14 and 15, all in the name of the Minister and all previously debated. Invite the Minister to move Amendments 13 to 15 en bloc. Does any member object to a single question being put on Amendments 13 to 15? No one has indicated an objection. The question is, Amendments 13 to 15 are agreed to. Are we all agreed? Thank you very much. The question is that Section 13 be agreed to. Are we all agreed? Thank you. The question is that Sections 14 and 15 be agreed to. Are we all agreed? Thank you. I call Amendment 92 in the name of Margaret Mitchell, grouped with Amendments 16, 93, 17, 94, 95, 18, 96 and 97. Margaret, please to move Amendment 92 and speak to all amendments in the group.
Thank you, Convener. Amendments 92 to 97 all cover the appointment of judicial members. These are merely probing amendments in order to hear the Minister's views on the following points. During Stage 1, a number of witnesses raised concern about what was referred to as the judicialisation of tribunals. Tribunals by nature are generally less formal and less adversarial than courts and are in the main forums where justice can be determined without the need for lawyers and judges. Section 16 of the bill allows all sheriffs and part-time sheriffs, judges and temporary judges to be appointed as judicial members of tribunals. Whilst the appointment of judicial members is appropriate in itself to allow tribunals to have access to important expertise, concern that this provision was drafted too widely was expressed by a number of witnesses. In particular, Section 16 states that all members of the judiciary are automatically eligible to act as judicial members purely by virtue of holding judicial office. Given the committee's view that the particular nature and characteristics of tribunals must be protected, will the Minister comment on the committee's recommendation in the Stage 1 report, namely that the Government should consider whether Section 16 should be amended to remove the automatic entitlement to appoint judicial members? The amendments in my name address this concern by making it clear that while sheriffs and judges are eligible to become judicial members, they must be actively appointed by the Lord President after consultation with the Lord President. The amendment therefore removes the use of the word authorised in section 16. More significantly, Amendment 94 provides for the appointment by the Lord President only when the President is satisfied that a sheriff or judge is suitably qualified. This would require the President to identify a placement, position and the need for a judicial member in a particular tribunal. The term suitably qualified is taken from Section 2 of the Lands Tribunal Act 1949 as amended. I should be grateful if the Minister could clarify in what instances judicial members would be appointed and respond to the suggestion that the automatic entitlement for appointments in Section 16 should be removed. In addition to this, would the Minister also indicate whether the Government has looked at any additional safeguards to avoid the judicialisation of tribunals? Do I move to have the discussion?
You can probe away, but you've got to move 92.
92.
Have you moved it?
I moved it.
Excellent. Minister, to speak to Amendment 16, please. And other
Thank you.
amendments
Margaret Mitchell's amendments change the language in sections 16 and 18 from referring to the authorisation of judges to act as judicial members of the first tier or upper tribunals to referring to the appointment of judges as such. It also imposes an additional duty on the President of Tribunals to be satisfied that the judge concerned is suitably qualified to act as such. Now, I agree at first blush these may seem like reasonably anodyne and unobjectionable changes, but they are fairly problematic and don't sit comfortably with other provisions of the bill. Firstly, if I can address the change of language to appointment. In the judicial and tribunal context, an appointment to a position normally refers to the process of appointment following an exercise by the Judicial Appointments Board for Scotland. The judges to whom sections 16 and 18 apply will already have been appointed as judges. They are already eligible to be judicial members of the Scottish tribunals under section 16, subsection 1 of the bill. Appointment is a term used for a specific process in the bill, such as in sections 21 or 25. The term authorisation is already used in section 17 of the bill and, in my view, better describes what will actually happen under these sections. The fact is that section 16 works perfectly well as it stands, and there isn't any need to change its approach. Calling this appointment is at best confusing and at worst dangerously casts doubt on the effect of the surrounding provisions and on the nature of the process. Secondly, the requirement that the President of Tribunals be satisfied that each judge is suitably qualified to act as such, in my view, is misconceived and fails to take into account the other protections in the bill. These ensure that only appropriate and qualified members sit in each jurisdiction operating in each chamber of the tribunal. These sections concern the authorisation of already appointed judges to act as judicial members of a tribunal, not as legal or ordinary members. Judicial members will only sit in tribunals where the composition order for that jurisdiction requires a judicial member to sit. For example, certain types of mental health tribunal are always chaired by a sheriff. Under Section 30 of the Act, the Lord President must publish an assignment policy which will control how members, including judicial members of the tribunal, are assigned to sit in cases in each tribunal jurisdiction. Taking the first-tier tribunal as an example by reference to Schedule 4, judicial members are assigned to a particular chamber by the President of Tribunals with the consent of the relevant chamber president. Once assigned, they are then selected to sit in individual cases by that chamber president under Section 34. In addition, assignment by virtue of Section 30 is designed to ensure that tribunal members are assigned in a way that ensures that best use is made of particular expertise in relevant areas of the law. On all of this, the equivalent is true under the corresponding provisions for the upper tribunal. This detailed and considered scheme represents, in my view, a much more focused, rigorous way to ensure that tribunals have as their members only those people who are most qualified to sit in any particular case. And in addition, I would point out something obvious, namely that sheriffs and judges are eminently qualified to exercise their judicial functions anywhere, whether in our courts or in our tribunals. It's not clear how Margaret Mitchell's proposed amendments would interact with this scheme, and they are not, I consider, necessary or desirable. Amendments 16 and 17 in this group make minor adjustments to the wording of section 16 for the sake of readability, but they involve no change in meaning or effect, and I would therefore invite Margaret Mitchell to withdraw Amendment 92.
Any other members wish to? Margaret.
Yes, these comments are very helpful and good to reflect on, very detailed, Minister, for stage through. I won't be moving Amendment 92.
No, you've moved 92. You're going to ask
withdraw.
If you can withdraw it. That's all right. I've got permission to withdraw 92. That's how I know what we're doing. It's not because I'm cleverer than you. Are you agreed? Committee's agreed. Thank you very much. The question is, sorry, it's not. I call Amendment 16 in the name of the Minister, already debated with Amendment 92. Minister to move formally. The question is that Amendment 16 be agreed to. Are we all agreed? Agreed. I call Amendment 93 in the name of Margaret Mitchell, already debated with Amendment 92. Move or not move, Margaret? Thank you. I call Amendment 17 in the name of the Minister, already debated with Amendment 92. Minister to move formally.
Moved.
The question is Amendment 17 be agreed to. Are we all agreed? Agreed. I call Amendment 94 in the name of Margaret Mitchell, already debated with 92. Margaret to move or not move?
Not moved, Convener.
I call Amendment 95 in the name of Margaret Mitchell, already debated with Amendment 92. Margaret to move or not move?
Not moved.
Call Amendment 18 in the name of the Minister, already debated with Amendment 92.
Moved.
Thank you very much. Formally, the question is that Amendment 18 be agreed to. Are we all agreed? Agreed. The question is that Section 16 be agreed to. Are we all agreed? Call Amendment 19 in the name of the Minister, group with Amendments 20 to 28. Minister, please to move Amendment 19 and speak the other amendments in the group.
Thank you. Amendment 19 adds the Chairman of the Land Court, judges and sheriffs, excluding part-time sheriffs, to the list of former office holders who can be authorised to sit in the upper tribunal. This is for consistency with the list of judges who are ordinarily eligible to sit in the upper tribunal. This allows further flexibility in the disposal of business in the upper tribunal should it be required, and is consistent with the eligibility of former judicial office holders to sit within the court's system. Amendment 24 ensures that former office holders cannot be authorised to sit if they have reached the age of 75 or if they were removed from office or are currently subject to fitness for office proceedings. Amendments 20 to 23 and 25 allow Scottish ministers to authorise non-Scottish judges to sit in the upper tribunal and to make arrangements with other administrations as are necessary. Amendment 25 also requires these judges to take the judicial oath where it has not been taken previously. These amendments make the provision for the use of non-Scottish judges more flexible. They allow for the use of court or tribunal judiciary to sit in the upper tribunal from any territory out with Scotland with the appropriate authorisations. Amendments 26 to 28 make minor adjustments and changes necessary to implement the other amendments. I move Amendment 19.
Thank you very much, Minister. Anyone else wishing to speak in this group? No one's indicated they do. Minister, I take you don't want to wind up. The question is that Amendment 19 be agreed to. Are we all agreed? Call Amendments 20 to 28, all in the name of the Minister and all previously debated. Minister, I invite you to move these en bloc.
Moved en bloc.
Does any member object to a single question being put to Amendments 20 to 28? No. The question is that Amendments 20 to 28 are agreed. Are we all agreed? Thank you very much. The question is that Section 17 be agreed to. Are we all agreed? Call Amendment 96 in the name of Margaret Mitchell, already debated with Amendment 92. Margaret, to move or not move?
Not moved, Convener.
I'll call Amendment 97 in the name of Margaret Mitchell, already debated with Amendment 92. Margaret, to move or not move?
Not moved, Convener.
The question is that Section 18 be agreed to. Are we all agreed? Thank you. Call Amendment 2 in the name of Elaine Murray, grouped with Amendments 3, 4 and 5, Elaine, please move Amendment 2 and speak to the other amendments in the group.
In its Stage 1 report, the committee welcomed the commitment to retain the Mental Health Tribunal in a chamber of its own within the first-tier tribunals, but was sympathetic to the Mental Health Tribunal's concerns that this commitment appears from the policy memorandum to be of a temporary nature. The committee recommended that amendments be brought forward to preserve the distinctiveness of the Mental Health Chamber. Mental Health Tribunal Scotland was created under the Mental Health Care and Treatment Scotland Act of 2003, with the intention of removing jurisdiction from the generic courts in Scotland and ensuring expertise. The MHTS has significant powers which other tribunals do not possess, such as the power to deprive someone of their liberty, impose treatment on a person, or conditions on how they may live, or how or where they may live. The provisions currently in the bill do not sufficiently protect and preserve the level of specialisation of the MHTS. These amendments do so by setting out in the face of the bill that the MHTS must be placed within a single chamber, in Amendments 2 and 3, and in 3 and 4 stating that the MHTS may not be transferred into the first-tier tribunal until provision has been made for a single chamber to adjudicate exclusively on the subject matter of mental health. I think that's actually 4 and 5 rather than 3 and 4. I noticed that in the notes that the Minister gave that there's objection to these on the basis that they would not allow other tribunals to be transferred into the same chamber as a mental health tribunal. But that's actually the very purpose of them, that the objection was to the idea was that the MHTS should remain within a chamber on its own. And I think if you start transferring others in, then you actually dilute that commitment.
Any other members? I have to say I'm sympathetic to your amendment, but let's hear what the Minister has to say to it. Minister.
Thank you, Elaine Murray.
Sorry. Need to speak. I told you, need to speak up. Right.
Obliged, Convener, merely to support the proposal. There was very strong evidence given to the committee from those engaged in this area of tribunal work that the relationships, the culture and the special knowledge that's exercised within that mental health tribunal was so distinctive that it not only deserved a section of its own, but it was important that it maintained the boundaries of that section for fear that in future years, whether by design or by accident, the nature of the way in which the business was conducted was changed to the extent that it would leave those approaching the tribunal in a position of being disadvantaged, for all the reasons that my colleague explained when she moved the amendment. And I would hope that the Minister would be sympathetic to the concerns that were expressed in that evidence.
I'm sorry, I don't think you actually did. You move it? I mean, we're both
I didn't
suffering
move the first
a little.
one. Yeah, I didn't move it. I started
yes.
Off, otherwise I forget.
Pay attention. Right. Minister.
Thank you. Elaine Murray's amendments seek to ensure on the face of the bill that there should be a single chamber exclusively for the Mental Health Tribunal. As I explained in my response to the committee following Stage 1, nothing, not one thing we are doing in this bill affects the work of the Mental Health Tribunal for Scotland, the specialism of its members, or the way the important decisions of this tribunal are made. And I think there still seems to be a fundamental confusion in people's minds between the concept of a tribunal and a chamber. Most significantly, the Mental Health Tribunal will still be governed by the Mental Health Care and Treatment Scotland Act. That is the legislation which sets up the Mental Health Tribunal and governs the way in which it works. And it will still adhere to the Milan principles. The intention is for it to be transferred into the new tribunal structure intact, with its jurisdiction unchanged. As the committee are aware, I've made a commitment to the Mental Health Tribunal being in a chamber of its own in the first instance. The bill is clear that only similar subject matters can be located together in a chamber. And I'd refer Elaine Murray to Section 19, which explicitly requires this to be paramount when deciding how to organise the first-tier tribunal into chambers. This requirement is inescapable. I don't think that we should entirely discount the possibility that a new tribunal jurisdiction could be created which would most naturally sit alongside mental health work in a chamber and which would benefit from shared chamber leadership. Even if this were to happen, Section 19 still ensures that co-location of something with mental health work would be only possible if done in accordance with the requirement already in Section 19. In any event, any creation of or change to the chamber structure can only happen following affirmative order by this Parliament and consultation where appropriate with stakeholders. 2 or more jurisdictions being located in the same chamber in no way amalgamates them or dilutes their specialism. The only thing they will share is a chamber president. Members will continue to be appointed by subject matter specific criteria. They will be appointed following the recommendation of the Judicial Appointments Board for Scotland. There is a duty on the Lord President at Section 30 to publish an assignment policy, as I've already indicated in a previous group. Subsection 3 specifies that the policy must make use of the knowledge and experience of the members of the Scottish tribunals. Section 35 of the Bill allows ministers by regulations to determine composition orders showing what types of members can hear what cases. The composition order can specify what relevant criteria must be met by the ordinary member. We must also not forget that it is the Chamber President who will pick the individuals to hear cases in their chamber. The Bill has many safeguards that ensure the only people who will be able to hear cases in the mental health jurisdiction will be those who have the skill, experience and knowledge to do so. We have engaged with stakeholders on this issue. The President of the Mental Health Tribunal and the Mental Welfare Commission are content with the safeguards in the Bill. They are also content with the commitment I made that the Mental Health Tribunal will be in a chamber of its own in the first instance. The amendments proposed by Elaine Murray do not offer any additional protection to the mental health jurisdiction, which is not already adequately addressed by the safeguards in the Bill, but it does restrict flexibility and the ability of a new tribunal structure to deal with new jurisdictions or new approaches in the future. I would therefore ask Elaine Murray to withdraw Amendment 2.
Elaine, wind up and press or withdraw.
I still am slightly confused by the argument about new tribunals, because I would have thought any new tribunal will be created through primary legislation, and therefore, were it considered by stakeholders to be necessary for a sharing of the tribunal, there is surely the opportunity to amend this Act at that point. So I think I will actually...
I'll let the Minister respond to that one.
It would be tempting to start to speculate where and in what area of wider mental health there might in future be a new tribunal set up, and I don't think it would be helpful if we did that. But we have to encompass the possibility that that will happen, and that if it does happen, it would be nonsensical, I think, not to allow for it simply to be in this chamber. Don't forget, if you assign this chamber to only the Mental Health Tribunal, then you're creating an issue in the future should another mental health related tribunal be set up for whatever reason by, in the future.
Yeah, my point actually was that any other tribunal will be set up through primary legislation. If it became necessary to change this, the opportunity to change this could be done through the subsequent bill, surely.
Well, you're both disagreeing, so I think you've aired your debate enough. I take it you're pressing.
I'll press it, yeah.
Pressing. The question is that Amendment 2 be agreed to. Are we all agreed? Yes. No. There'll be a division. Those in favour, please show. Those against, please show. 4 for, 5 against. There's no abstentions. It's disagreed. Call Amendment 3 in the name of Elaine Murray. Already debated with Amendment 2. Move or not move, Elaine? Not Thank you. The question is that Section 19 be agreed to. Are we all agreed? The question is that Sections 20 to 25 be agreed to. Are we all agreed? Call Amendment 29 in the name of the Minister. Already debated with Amendment 1. Minister to move formally.
Formally moved.
The question is that Amendment 29 be agreed to. Are we all agreed? The question is that Section 26 be agreed to. Are we all agreed? Call Amendment 30 in the name of the Minister. Already debated with Amendment 1. Minister to move formally.
Formally moved.
The question is that Amendment 30 be agreed to. Are we all agreed? The question is that Schedule 1 be agreed to. Are we all agreed? The question is that Sections 27 and 28 and Schedule 2 be agreed to. Are we all agreed? Call Amendment 31 in the name of the Minister. Already debated with Amendment 6. Minister to move formally.
Formally moved.
The question is that Amendment 31 be agreed to. Are we all agreed? Call Amendment 32 in the name of the Minister. Already debated with Amendment 6. Minister to move formally. Thank you. The question is that Amendment 32 be agreed to. Are we all agreed? The question is that Section 29 be agreed to. Are we all agreed? Call Amendment 33 in the name of the Minister, grouped with Amendments 34 to 45 and 86 to 88. Minister, please to move Amendment 33 and speak to all the amendments in the group.
Amendments 33 and 34 amend Schedules 3 and 5 as they relate to the appointment of lawyers as legal members of the new tribunals. I've reflected on the recommendation in the committee's Stage 1 report that only those qualified in Scots law can conduct business in devolved tribunals. These amendments therefore remove the automatic right for a solicitor or barrister in England and Wales or Northern Ireland to be appointed as a legal member of the Scottish tribunals. Amendment 36 addresses the concerns expressed at Stage 1 by the committee and the Lord President that the bill should allow for the possibility of permanent appointment to the Scottish tribunals. This is achieved by allowing the Scottish ministers, by regulations, to affect the operation of Schedule 7, which contains the provisions which automatically reappoint tribunal members on 5-yearly terms of appointment. Scottish ministers, after consulting with the President of tribunals, may make these regulations in respect of a particular appointment or position in the Scottish tribunals. So, for instance, this power could be used to provide that the position of Chamber President of a particular chamber of the first-tier tribunal or Vice President of a particular division of the upper tribunal could become a permanent appointment. This future-proofs the bill and provides a more flexible scheme of appointments for jurisdictions which might transfer in the future. Amendment 37 confirms the provision that where a legal member obtains a new position, for example being appointed as a Chamber President, their 5-year appointment term will begin from the day they take up that new office. This ensures that they will have a full 5-year term in their most recently appointed office. Amendment 86 is a transitional provision. This increases the pool of people eligible to sit on the Judicial Appointments Board for Scotland and take part in recruitment exercises. This is to allow for when there is only one or a small number of tribunals in the new structure. As currently drafted, when the first tribunal is transferred into the new structure, only the President of that tribunal would be eligible to sit on the Judicial Appointments Board. This amendment allows people holding leadership positions in those tribunals listed in Schedule 1 of the bill to also participate in the work of the Judicial Appointments Board prior to their tribunal being transferred in. Amendments 35, 38 to 40, Amendments 35, 38 to 45, 87 and 88 make the necessary adjustments, rewordings and rearrangements to implement these substantive changes or for other minor or drafting reasons. I move Amendment 33.
Thank you very much. Do other members wish to? I've got Roddy, then Margaret.
Sorry, just briefly, I'd like to thank the Minister for taking note of the committee's comments and the Lord President's comments on the need to provide some flexibility for permanent appointments.
Well, just future-proofed your career by thanking the Lord President there, Roddy. Margaret.
I take it originally, Minister, the reason for including English barristers as legal members would be to ensure that there was a width of kind of expertise available, and taking on board the committee's recommendation only those qualified in Scots law should be eligible. By removing English barristers, are we removing the possibility of using the expertise of these barristers who may also be qualified in Scots law?
If they're qualified in Scots law, they're qualified. This doesn't exclude those who have dual qualifications. It only excludes those who have no qualification in Scots law. We can always reintroduce it in future if, for whatever unknown reason, we consider it, to be something that you would want to do. But I'm not clear that people, would necessarily understand that. I think the situation that we have at the moment is more historic than anything else.
Doesn't remove English barristers as legal members per se. It's only these ones who wouldn't be qualified in Scots law as well.
If they're qualified in Scots law, then they are qualified in terms of this bill. Sorry? Yeah, I mean, there would have to be a member of the Faculty of Advocates or a member of the Law Society here. And I am aware that there are people who are qualified in both jurisdictions. That is not... I mean, while it's not common, it does happen. I think I may be right in saying that you have a member of this committee qualified in both jurisdictions. No, I thought.
Once upon a time.
I'm sorry, I thought Roderick Campbell was.
Once upon a time, historically, but not. I'm only authorised to practice in Scotland at the current time.
Yeah, some people do qualify in both or in more than one jurisdiction, not just with English jurisdiction, because you know.
Okay.
Elaine, you want to come in?
Just really for a point of clarification, in the event, and I know the UK government is not keen on this at the moment, but the event of the reserve tribunals transferring across into our jurisdiction, is there a problem then with excluding barristers and people who are...
Well, that's why I think I'm putting on the record that if there's a need to reintroduce in the future, then we would have to do that. But at the moment, that's not something which we're... This Tribunals Bill is really directed only at the devolved tribunals.
Okay, right, well, that's it. Minister, do you wish to wind up, or have you answered all questions?
We've done that.
The question is that Amendment 33 be agreed to. Are we all agreed? The question is that Schedule 3 be agreed to. Are we all agreed? The question is that Schedule 4 be agreed to. Are we all agreed? Call Amendment 34 in the name of the Minister. Already debate with Amendment 33. Minister to move formally.
Moved.
The question is that Amendment 34 be agreed to. Are we all agreed? Oops. The question is that Schedule 5 be agreed to. Are we all agreed? The question is that Schedule 6 be agreed to. Are we all agreed? The question is that Sections 30 and 31 be agreed to. Are we all agreed? Call Amendment 35 in the name of the Minister. Already debated with Amendment 33. Minister to move formally.
Moved.
The question is that Amendment 35 be agreed to. Are we all agreed? Call Amendment 36 in the name of the Minister. Already debated with Amendment 33. Minister to move formally. The question is that Amendment 36 be agreed to. Are we all agreed? The question is that Section 32 be agreed to. Are we all agreed? Call Amendments 37 to 45, all in the name of the Minister and all previously debated. Invite the Minister to move these amendments, 37 to 45, en bloc.
Moved en bloc.
Does any member object to a single question we put on these amendments? The question is Amendments 37 to 45 are all agreed to. Are we agreed? The question is that Schedule 7 be agreed to. Are we all agreed? The question is that Section 33 be agreed to. Are we all agreed? Call Amendment 46 in the name of the Minister, group with Amendments 47 and 48. Minister, please to move Amendment 46 and speak to the other amendments in the group.
Thank you. I can be very brief. The Lord President raised concerns in his Stage 1 written evidence about the possibility that a fitness assessment tribunal could be convened without a full-time judge. By removing the provision for part-time sheriffs and excluding temporary judges and making other changes, Amendment 46 ensures that there will always be a full-time judicial member within the composition of a fitness assessment tribunal. I move Amendment 46.
Very much. Any other member wish to speak? Thank you. Minister, I take it you don't want to wind up. The question is that Amendment 46 be agreed to. Are we all agreed? Call Amendment 47 in the name of the Minister. Already debated with Amendment 46. Thank you very much. Move formally. The question is that Amendment 47 be agreed to. Are we all agreed? Call Amendment 48 in the name of the Minister. Already debated with Amendment 46. Minister, move formally. The question is that Amendment 48 be agreed to. Are we all agreed? The question is that Schedule 8 be agreed to. Are we all agreed? Call Amendment 49 in the name of the Minister. Already debated with Amendment 9. Minister, to move formally.
Moved.
The question is that Amendment 49 be agreed to. Are we all agreed? The question is that Section 34 be agreed to. Are we all agreed? The question is that Section 35 be agreed to. Are we all agreed? Call Amendment 50 in the name of the Minister. Already debated with Amendment 9. Minister, to move formally. The question is that Amendment 50 be agreed to. Are we all agreed? Call Amendment 51 in the name of the Minister. Already debated with Amendment 9. Minister, to move formally.
Moved.
The question is that Amendment 51 be agreed to. Are we all agreed? The question is that Section 36 be agreed to. Are we all agreed? The question is that Section 37 be agreed to. Are we all agreed? Call Amendment 52 in the name of the Minister. Already debated Amendment 9. Minister, to move formally.
Moved.
The question is that Amendment 52 be agreed to. Are we all agreed? Call Amendment 53 in the name of the Minister. Already debated with Amendment 9. Minister, to move formally. The question is that Amendment 53 be agreed to. Are we all agreed? The question is that Sections 38 to 44 be agreed to. Are we all agreed? Call Amendment 54 in the name of the Minister. Group with Amendments 55 and 56. Minister, please to move Amendment 54 and speak to the other amendments in the group.
Thank you, Convener. Amendments 54 and 55 are minor drafting adjustments. They align the language of the second appeals test exactly with other statutory examples of this test. Amendment 56 deals with switching off appeal rights. The Delegated Powers and Law Reform Committee felt this provision allowed a choice of appeal routes. We've included this amendment to ensure that no choice of appeal routes can or would be created under these provisions. I move Amendment 54.
Very much. Any other members wish to speak? I take it you don't wish to wind up. The question is that Amendment 54 be agreed to. Are we all agreed? Call Amendment 55 in the name of the Minister. Already debated Amendment 54. Minister to move formally.
Moved.
The question is that Amendment 55 be agreed to. Are we all agreed? The question is that Section 45 be agreed to. Are we all agreed? The question is that Sections 46 and 47 be agreed to. Are we all agreed? Call Amendment 56 in the name of the Minister. Already debated with Amendment 54. Minister to move formally. The question is that Amendment 56 be agreed to. Are we all agreed? The question is that Section 48 be agreed to. Are we all agreed? The question is that Sections 49 to 55 be agreed to. Are we all agreed? You're running out of steam. That was a very limp agreed. Try to be enthusiastic. Call Amendment 57 in the name of the Minister. Group with Amendments 58 to 66, 69 to 72 and 85. Can I point out that Amendment 85 is preempted by Amendment 99 in the group, Rulemaking Transitional Arrangements. Minister, can I ask you please to move Amendment 57 and speak to all the amendments in the group?
Thank you. Amendments 57 to 59 clarify that hearings can be held at any time as well as any place in Scotland. They also allow tribunal rules to determine when and where hearings take place. These amendments also allow the determination of when or where hearings take place to be made by the President of Tribunals under tribunal rules. These amendments better explain the role and function of tribunal rules and the President of Tribunals as regards this issue. Amendments 60 to 66 and 85 make minor adjustments, rearrangements and changes for the sake of overall sense and effect. For instance, 63 to 66 rearrange the provisions on wasted expenses for improved readability. Amendments 69 to 72 make some adjustments to Section 63, which concern the way in which tribunal rules may deal with the functions of members of the Scottish tribunals. These amendments clarify that rules may also confer functions on and deal with the functions of the particular post holders listed in Amendment 72. Amendment 71 clarifies that this does not refer to the function of actually deciding any matter in a case before the first tier or upper tribunal. Rather, it refers to the procedural or administrative functions of tribunal members and those in leadership posts. I move Amendment 57.
Very much. Elaine, you want to speak?
Just to ask the Minister about the issue of wasted expenses, which we just touched on in the first stage debate. None of us were terribly sure what it was, I think including yourself, Minister. There still doesn't seem to be any definition as to what wasted expenses are, and I just wondered whether that's something that will be addressed at stage 3.
I see one of my officials scribbling furiously. We may get some clarity on this.
I think somebody would say it's a pair of shoes I shouldn't have bought.
Any minute now. Okay, thank you. This is transparent government. I hope you're impressed. Wasted expenses are awarded to express judicial disapproval of unnecessary steps in litigation. I guess it's one of those legal terms, wasted expenses, which doesn't mean legally what ordinary English might suggest it would mean.
Not shoes.
Not shoes. There are a number of similar. There are a number of similar sorts of expressions that come up. So that's basically what it means. It's a judicial disapproval, and this, I suppose, it sounds almost like a punishment expense. And I guess I'm getting some nods here, so that's really what it is. I mean, if that helps people to understand it better.
I think our resident advocate is about to.
It's a purely English concept, but just to point, it's a purely English concept at the present time. But just to point out that Section 59(4) does provide that rules may prescribe a meaning for wasted expenses. So obviously, that might be something the Minister won't want to take on board at some stage, just to actually define it.
You should be sitting over there, I think. The officials, I think that was a... I'm so sorry, I'm offending the officials. I'm getting looks on them. There we are. There we are. We have exhausted what wasted expenses are. We've not wasted time talking about it. Now, can I ask the Minister, do you wish to wind up? I think we've... No. The question is that Amendment 57 be agreed to. Are we all agreed? Yes. Call Amendment 58 in the name of the Minister. Already debated with Amendment 57. Minister, to move formally.
Moved, sorry.
The question is that Amendment 58 be agreed to. Are we all agreed? Yes. The call Amendment 59 in the name of the Minister. Already debated with Amendment 57. Thank you very much. The question is that Amendment 59 be agreed to. Are we all agreed? The question is that Section 56 be agreed to. Are we all agreed? Call Amendment 60 in the name of the Minister. Already debated with Amendment 57. Minister, to move formally. The question is that Amendment 60 be agreed to. Are we all agreed? The question is that Section 57 be agreed to. Are we all agreed? The question is that Section 58 be agreed to. Are we all agreed? Call Amendments 61 to 66, all in the name of the Minister and all previously debated. Minister, I invite you to move them en bloc.
En bloc.
Does any member object to a single question being put on Amendments 61 to 66? Thank you. The question is that Amendments 61 to 66 are agreed to. Are we all agreed? Thank you very much. The question is that Section 59 be agreed to. Are we all agreed? The question is that Section 60 and 61 be agreed to. Are we all agreed? Call Amendment 67 in the name of the Minister. Group with Amendment 84. Minister, please to move Amendment 67 and speak to the other amendment.
Thank you, Convener. Amendment 67 allows offences to be created in connection with tribunal proceedings for things like making false statements and concealing or destroying evidence. Where tribunal jurisdictions require provision of this sort, Scottish ministers will be able to make it under this section. This is all consistent with the equivalent provisions currently governing the Mental Health Tribunal. This amendment also allows regulations to be made which specify the circumstances in which a person cannot be compelled to give or produce evidence. Amendment 84 is made as a consequence of Amendment 67, and I therefore move Amendment 67.
Very much. Any other member wish to come in? Nobody does. Minister, I know you don't think you want to wind up. The question is that Amendment 67 be agreed to. Are we all agreed? Call Amendment 68 in the name of Elaine Murray. Already debated Amendment 8. Elaine, to move or not move?
Not moved.
The question is that Section 62 be agreed to. Are we all agreed? Call Amendments 69 to 72, all in the name of the Minister and all previously debated. Minister, to move en bloc.
Moved en bloc.
Does any member object to a single question on Amendments 69 to 72? The question is that Amendments 69 to 72 are agreed to. Are we all agreed? The question is that Section 63 be agreed to. Are we all agreed? Call Amendment 73 in the name of the Minister. Already debated Amendment 9. Minister, to move formally. The question is that Amendment 73 be agreed to. Are we all agreed? The question is that Section 64 be agreed to. Are we all agreed? Call Amendment 74 in the name of the Minister. Already debated Amendment 9. Minister, to move formally.
Moved.
The question is that Amendment 74 be agreed to. Are we all agreed? The question is that Section 65 be agreed to. Are we all agreed? Call Amendment 75 in the name of the Minister. Already debated Amendment 9. Minister, to move formally. The question is that Amendment 75 be agreed to. Are we all agreed? The question is that Section 66 be agreed to. Are we all agreed? Call Amendment 76 in the name of the Minister. Already debated Amendment 9. Minister, to move formally.
Moved.
The question is that Amendment 76 be agreed to. Are we all agreed? The question is that Section 67 be agreed to. Are we all agreed? Call Amendment 77 in the name of the Minister. Group with Amendments 78, 81. Minister, please to move Amendment 77 and speak to the other amendments in the group.
Thank you, Convener. We were persuaded by the arguments put forward by stakeholders and in the evidence at stage 1 that practice directions should not issue guidance on the interpretation of the law. Amendment 77 therefore removes this provision. The Delegated Powers and Law Reform Committee recommended that there should be a statutory requirement for directions to be published. Amendment 79 therefore requires the President of Tribunals to arrange publication of directions. Amendments 78, 80 and 81 rearrange the provisions of sections 68 and 69 as a consequence of these changes in light of other amendment and for other minor purposes. I move Amendment 77.
Thank you. Do any members wish to speak? Roddy?
Yes, once again to thank the Minister for listening to the considerable concerns about Section 68.5 and to welcome the withdrawal.
Anyone else? Thank you. Minister, do you wish to wind up? No. The question is, Amendment 77 be agreed to. Are we all agreed? Call Amendment 78 in the name of the Minister. Already debating Amendment 77. Minister, to move formally. The question is that Amendment 78 be agreed to. Are we all agreed? The question is that Section 68 be agreed to. Are we all agreed? Call Amendment 79 to 81, all in the name of the Minister and all previously debated. Minister, I invite you to move these en bloc. Does any member object to a single question we put on Amendment 79 to 81? The question is that Amendment 79 to 81 are agreed to. Are we all agreed? The question is that Section 69 be agreed to. Are we all agreed? Call Amendment 82 in the name of the Minister and a group on its own. Minister, please, to move and speak to that amendment.
Convener, the committee recommended at stage 1 that there should be a requirement for consultation if there were any plans to introduce fees for tribunals where there were none previously. Members will remember there was a discussion about fees, and one tribunal had been set up on the basis of there being fees already as part of the structure. Amendment 82 puts a duty on the Scottish ministers to consult stakeholders with an interest in tribunals before making any regulations with regard to the introduction of fees. And as I stated in my response to the committee's Stage 1 report, it is not the Scottish Government's intention to use the provisions in Section 70 to introduce new fees in tribunals. I move Amendment 82.
Does any member wish to speak? Elaine?
Just to welcome it, clearly it was a concern, particularly around the way and the scale of fees in some of the reserve tribunals on employment and so on. And good to see a guarantee of consultation if there's any such.
Yes, we were doing our work. We were doing our work at stage 1 and were responded to. So, Minister, just you don't want to wind up, do you? No, not at all. The amendment. The question is that Amendment 82 be agreed to. Are we all agreed? The question is that Section 70 be agreed to. Are we all agreed? The question is that Section 71 and 72 be agreed to. Are we all agreed? Call Amendment 83 in the name of the Minister. Already debating Amendment 9. Minister, to move formally. The question is that Amendment 83 be agreed to. Are we all agreed? Call Amendment 84 in the name of the Minister. Already debated with Amendment 67. Minister, to move formally. The question is that Amendment 84 be agreed to. Are we all agreed? The question is that Section 73 be agreed to. Are we all agreed? The question is that Sections 74 and 75 be agreed to. Are we all agreed? Call Amendment 98 in the name of Margaret Mitchell, group with Amendment 99. I point out to you that if Amendment 99 is agreed to, I cannot call Amendment 85, previously debated the group tribunal rules, because it's preempted. Margaret, please, to move Amendment 98 and speak to the other amendments in the group.
Thank you, Convener. Amendments 98 and 99 relate to the issue of tribunal independence. The Bill currently allows Scottish ministers to draft procedural rules by virtue of Schedule 9, paragraph 4. The Scottish Government intention is that this will be an interim arrangement before the newly created Scottish Civil Justice Council has the capacity to take over responsibility for these rules. The Council will certainly have a very heavy workload drafting new civil court procedural rules, and I do understand and agree with the Government's intention to ensure that rules are drafted as soon as possible. I also appreciate that someone has to draft the rules for the newly created Upper Tribunal. In response to the Stage 1 report, the Ministers made the point that the Government currently has a limited role in writing some tribunal rules, and that in terms of the new tribunal landscape, it will only draft rules following consultation. However, the committee heard at Stage 1 that this arrangement was undesirable on constitutional grounds. The Faculty of Advocates argued that Scottish ministers should have the same rights as other parties to proceedings before tribunals to comment on proposed rules, but should not have the power to write them. This is, therefore, a very serious matter. In fact, decisions taken by Scottish ministers and Scottish Government agencies can themselves be subject to tribunal consideration. This in turn means, as the interim power provision stands, that the Scottish Government is effectively acting as linesman in a match in which it is participating. The interim rule-making power gives ministers more power than they currently enjoy. This is because the rules have to be written for the upper tribunal, which will deal with cases that are more serious and therefore more politically sensitive. Furthermore, the rule-making power does not specify a time limit, meaning Scottish ministers could retain the power indefinitely. I do not consider that this is a satisfactory situation because giving the power to ministers, even as an interim measure, breaches the important principle of separation of powers. In addition to this, I believe there are potential problems for the future if an aggrieved party who has lost a tribunal hearing against the government later learns that the rules were drafted by Scottish ministers. I understand why the bill takes the approach it does, given the Scottish Civil Justice Council has a huge task ahead of it. Nonetheless, the government could and should ensure the Council is appropriately resourced to take this role on from the start. A new committee of the Council will be created at some point down the line, so it should be created now. Amendment 98 therefore replaces the relevant provisions in paragraph 4 and 5 to ensure that rules currently in place are to be regarded as if made as new tribunal rules until and if these rules are amended. I move Amendment 98 in my name.
Thank you very much. Anyone else wish to come in? Roddy.
I heard what Margaret Mitchell said, and I have a great deal of sympathy with it in constitutional terms. It's clearly not ideal at all, and obviously we had a number of stakeholders who gave evidence to that effect. On the other hand, the practicality is we also heard evidence that there is no way that Scottish Civil Justice Council could embark upon this venture at the current time. I was wondering whether it would be possible before stage 3 for the Minister to reflect on whether these ought to be some provision that any rules made by the government, even after consultation in the short term, would be subject to a kind of prompt to review by the Scottish Civil Justice Council at some point, so that they wouldn't necessarily be allowed to carry on ad infinitum, as it were, without being subject to a proper and full review.
Minister.
We'll always listen to suggestions, and we'll take that forward and have a think about it. But I need to restate that this transitional provision is what currently is the case and has been the case for all previous governments and all previous ministers, not just this government. What is being discussed here is the way things have been done right throughout the tribunal experience. We may now, as a result of the conversations around this legislation, come to a view that should come to an end. And that's what we have done, in effect, come to a view that should come to an end. All this bill does is ensure that the transition towards that end point is as seamless as it can be. It doesn't confer any new powers on ministers, regardless of who's in government. It simply continues the existing powers of ministers, the ones that have always been exercised by ministers, and it foresees that there will be an end point to that. In his Stage 1 written evidence, the Lord President supported the transitional arrangements for the making of tribunal rules by the Scottish ministers. Discussions with his judicial office indicated that the Lord President would like to concentrate on the significant task of rewriting the court rules before taking on the work of tribunals. The transitional arrangements are merely a continuation of the current practice. I would not wish to place an additional burden on the Lord President and the Scottish Civil Justice Council before they felt able to take on this new task. Neither the removal of the transitional period by Amendment 99 nor the consequential change to the nature of rules during the transitional period by Amendment 98 are therefore desirable. I'm satisfied that the detailed scheme in Schedule 9 for transitional rulemaking is the best way forward. This transitional phase, during which rules are made by the Scottish ministers, has additional protection built into it. Rules are subject to negative parliamentary procedure, and there is a consultation requirement imposed on the Scottish ministers. I believe that this is a sufficient safeguard for ensuring that any rules made by the Scottish ministers are suitable for application in the tribunal's systems. And if I could just remind people that the ministers are doing rules now and have been for many, many decades. It is a continuation of that procedure. And in making rules, ministers will always take expert advice. This section of the bill is really about timing, not resources. We've committed to providing the resources when required by the CJC and the Lord President. I would therefore ask Margaret Mitchell to withdraw Amendment 98.
To wind up, please press for withdraw.
Thank the Minister for these comments, which I don't find convincing. The fact that it's been done in a certain way in the past doesn't necessarily mean it's the way to continue, because we are looking at a new set of circumstances here, Ministers. The powers are really more because they relate to the upper tribunal, which has the potential to deal with very serious and also politically sensitive cases. And I don't believe the Minister has addressed the potential problem of the Scottish Government being subject to a tribunal case, winning that case, and then the person who loses the case discovering that it was the ministers themselves who set the rules, and I think that is a potential problem. I fully understand that the council, Civil Justice Council that will be created, will have its hands very much full with civil procedural rules, and I understand that the Lord President will want to get on with that, but that doesn't stop the council being adequately resourced to allow it to deal with the interim rules in the meantime. So for all these reasons, Convener, I intend to move
You're pressing it. Thank you very much. The question is that Amendment 98 be agreed to. Are we all agreed? No. There will be a division. Those in favour, please show. Those against, please show. Oh, there are no abstentions, so that's 1 for, 8 against, no abstentions. That's disagreed. Call Amendment 99 in the name of Margaret Mitchell. Ready debate Amendment 98. Can I remind you that if Amendment 99 be agreed to, I cannot call Amendment 85. Margaret, to move or not move?
Moved, Convener.
The question is that Amendment 99 be agreed to. Are we all agreed? Those in favour, please show. Those against, please show. There's 1 for, 8 against, no abstentions. That is disagreed. Call Amendment 85 in the name of the Minister. Already debated Amendment 57. Minister, to move formally.
Moved.
The question is Amendment 85 be agreed to. Are we all agreed? Agreed. Call Amendment 4 in the name of Elaine Murray. Already debated with Amendment 2. Elaine, to move or not move?
Not moved.
Thank you. Call Amendment 5 in the name of Elaine Murray. Already debated with Amendment 2. To move or not move? Not moved. I call Amendments 86, 87 and 88, all in the name of the Minister and all previously debated. Minister, I invite you to move these on block.
Moved on block.
Does any member object to a single question being put to these? No. The question is that Amendments 86 to 88 are agreed to. Are we all agreed? Call Amendment 89 in the name of Elaine Murray, grouped with Amendments 90 and 91. Elaine, please, to move Amendment 89 and speak to the other amendments in the group.
Thank you, Convener. I move Amendment 89. Citizens Advice Scotland, who, as we all know, specialises in taking people through the tribunal's process, advise that in Scotland there has been a clear and statutory link between the oversight of tribunals and the making of procedural rules since 1957. However, they believe that this is broken by this bill in its current form. Citizens Advice has major concerns about the current arrangements and the gap between oversight and the making of rules, and point out that the functions of the Scottish Civil Justice Council are imbalanced with regard to the treatment of administrative and civil justice. The SCJC has a much wider policy and oversight function for civil justice, and the scope of what it can achieve for tribunals is much narrower. As the committee is aware, an interim committee on administrative justice and tribunals is to be established as an independent advisory committee to ministers, and ministers will exercise the function of making procedural rules. At some stage, this function will pass to the SCJC, but without the duties of oversight and development being defined. My amendments 89, 90 and 91 seek to remedy this by giving the SCJC the same statutory functions for administrative justice as it holds for civil justice. Amendment 89 requires SCJC to keep matters relating to the administrative justice system within the jurisdiction of the Scottish Tribunals under review. Amendment 90 inserts a duty to provide advice and make recommendations to the Lord President about the development of and changes to such matters. And 91 requires the SCJC to provide advice on any such matter when requested by the Lord President.
Any other members? Roddy?
Murray's had to say, and obviously I raised this issue, I think, at the stage 1 debate, and obviously I've read the Citizens Advice Scotland briefing too. I've got considerable sympathy with this because it seems to me that there is a gap which will emerge, but at the same time we have an interim committee, and it really rather depends on what happens after the interim committee. And at this stage, it seems to me that if we were just to agree to Elaine Murray's amendment, we would be kind of reducing the flexibility to think about how the tribunal system is best overseen in the future. But I would be very pleased to hear the Minister's views on the matter.
Yes, and before we move on, I would endorse what Roddy says. I'm very sympathetic to the position of CAB, who are the link really between what is the informality, perceived informality of the tribunal system and tribunals, and provide a very important service there. So I'm also interested in the Minister's response.
I think I need to remind members that administrative justice is wider than tribunals and covers all redress mechanisms for citizens to challenge or complain about a decision made by a public body. It is not confined to what happens in tribunals, and it includes the courts, obviously, and tribunals, but it's not confined to them. It is more appropriate that those who are to have an overview are not part of the system they're scrutinising, and have set up a non-statutory committee to keep the administrative justice and tribunal landscape under review. The committee's work is already well underway. They're developing their work plan, and I understand will be holding a stakeholder event in April and will publish their progress online. This addition to the bill suggested by Elaine Murray would actually be replicating work that is already underway and is wider than tribunals alone. The bill ensures that the Scottish Civil Justice Council must establish a particular committee for the purpose of making tribunal rules. This committee will be chaired by the President of Tribunals, who, when selecting members for the committee, has to consider the need to choose members who have knowledge of how the Scottish tribunals exercise their functions. I believe this safeguard will ensure that tribunal rules are made with the appropriate expertise and with the user in mind, and I therefore ask Elaine Murray to withdraw Amendment 89.
In summing up, I wonder whether it would be possible to get more detail prior to stage 3 about the process which is already underway. I've been content to withdraw the amendments pending seeing a bit more detail on that process.
I mean, the existence of the committee is in no doubt. I can ensure that something straightforward is put to members that explains what is currently happening and what the immediate future holds. I'm not sure when stage 3 will be, though, so I'm not quite sure where this interim committee will be at in terms of their work by the time we're discussing it at stage 3.
Okay. Well, I'm content to withdraw at the moment, and hopefully we can get
Elaine
more.
Murray wishes to withdraw. Are you content when she does it? Thank you very much. I call Amendment 90 in the name of Elaine Murray. Are ready to wait for Amendment 89. Move or not move?
Not move.
Call Amendment 91 in the name of Elaine Murray. Are ready to wait for Amendment 89 to move or not move?
Not moved.
The question is that Schedule 9 be agreed to. Are we all agreed? The question is that Section 76, Schedule 10 and Sections 77 and 78 be agreed to. Are we all agreed? The question is that the long title be agreed to. Are we all agreed? Well, that ends stage 2 consideration of the bill. Thank you very much, committee. Thank you very much to the Minister and her officials. And we're going to be moving into private session, but I'm suspending for 10 minutes break anyway. We've got to get the screen set up.